All rise. I hope with the benefit of an extra half hour, everyone will have their allotted time.
We're extremely grateful. Thank you very much. If we can now just take up Mr. Justice Mumby's judgment on the question of justification, we can see how he approached the question. This is page 74 at Appendix Part 1. Paragraph 192. Mr. Justice Mumby identified the legitimate aim. And he identified it as follows. It is to educate those who, in the eyes of the OCR, are Jewish, irrespective of their religious beliefs, practices or observances, in a school whose culture and ethos is that of Orthodox Judaism. And he says that's what the school's adjudicator found, and he thinks he was right. And there was no appeal against that finding by the school. And of course, that is significantly different from the legitimate aim now being asserted before this court. He then came on to consider the question of justification. And if I can just point out to the court, at paragraph 198, he refers to a submission of Mr. Oldham, saying that my assertions of irrationality were misconceived because it was another instance of E's refusal to accept the consequences of the fact that it's Orthodox Judaism's belief that observance has nothing to do with Orthodox status, and that, as he correctly observes, correctly that is from the perspective of Orthodox Judaism, non-observant Orthodox Jews are Jews, whilst the observant of other Jewish religious groups are not. Now, in that form, of course, the assertion is plainly incorrect, because the office of the chief rabbi accepts that the observant of other Jewish religious groups are Jews, provided that their mother was born Jewish.
Sorry, he accepts that they're what?
The chief rabbi accepts that the observance of other Jewish groups, the observant Jews who are Masorti or Reform Jews, are Jews, provided their mother was born Jewish. The chief rabbi accepts that.
Yes, I see.
So that assertion is, of course, incorrect. But more fundamentally, if it's meant to be a telescoped way of saying the observant of other Jewish religious groups whose mothers are not Jewish in accordance with the views of the office of the chief rabbi are not Jews,
Quite.
Which is the only sense in which it's accurate, then that demonstrates the point I was making earlier, that at that stage, it was not being asserted on behalf of the school or the chief rabbi that there was any difference between an ethnic Jew and a Jew recognised by the chief rabbi. They were maintaining the position that the school had taken in its response to the questionnaire, which is those we consider to be halakhic Jews, we consider to be Jews. Those who we don't consider to be halakhic Jews, we don't consider to be Jews. And then he comes on to deal with the question of the balancing act. He says the only remaining question is whether the policy, given that it pursues a legitimate aim, can be justified as a proportionate and necessary means to that aim. Ms. Rose submits not, asserting that JFS's admissions policy does not properly balance the impact of the policy on those like M adversely affected by it and the needs of the school. The school's adjudicator did not agree, nor do I. So what you think when you read that is, okay, he's now going to go on to explain why there is a balancing. But he doesn't. What he then does is to say, in the following paragraph, that this type of admissions policy is not materially different from that which gives preference to admissions in a Muslim school to those who are born Muslim or to baptised Catholics. With great respect to Mr. Justice Mumby, that is a matter of complete irrelevance to the question that he was being asked to determine, namely, has the school balanced the adverse impact on the disadvantaged children with the importance of maintaining the policy? And then at 201, he says the other point that's made Adopting some alternative admissions policy based on such factors as adherence or commitment to Judaism, even assuming such a concept has any meaning for this purpose in Jewish religious law, would not be a means of achieving JFS's aims and objectives. On the contrary, it would produce a different school ethos. If JFS's existing aims and objectives are legitimate, as they are, then a policy of giving preference to children who are Jewish, applying Orthodox Jewish principles, is, they say, necessary and proportionate. Indeed, as it seems to me essential to achieve those aims. Mr. Oldham puts the point very clearly. JFS exists as a school for Orthodox Jews. If it is to remain a school for Orthodox Jews, it must retain its existing admissions policy. If it does not, it will cease to be a school for Orthodox Jews. Precisely. To this argument, there is and can be no satisfactory answer. Now, there are a number of problems with that analysis. The first is, of course, that again, does not seek to identify the severity of the impact on the disadvantaged group and to consider the question whether the rights and needs of that group can properly be said to outweigh the need of the school to maintain the policy. The fact that the school has an aim which can only be met by a particular policy doesn't give it an absolute right to retain the policy, regardless of the severity of the impact of that policy on a particular racial group. There will be circumstances where a school or an employer has a perfectly legitimate aim, and there's only one way of meeting that aim, but the effect of that aim on a particular racial group or women or men is so great that the court will say, I'm sorry, you've got to do something else. That point is completely missed here. The next point is that there's an internal confusion here because the focus here is not at all on the question of drawing children to the faith, which didn't feature at all in the argument of the school before Mr. Justice Mumby. His concern is with maintaining the school's ethos. And that's the school's ethos as set out in the instrument of government, saying that this school is to teach Judaism in accordance with Orthodox principles. And the argument is that that ethos would in some way be undermined by the admission of children who were not halakhically Jewish. And the submission that we made, and the submission that we maintain, is that it is impossible to see how that can be. Because if you have a school where there are, say, 300 children in Year 7, and of those, perhaps 50% are Orthodox in practice, perhaps 30% are Reform, Liberal or Masorti, and the remaining 20% are either atheist or practice a completely different faith, such as Christianity, how will adding 5 children to that group who are practicing Reform or Masorti Jews, but who are not halakhically Jewish, have any effect on the school's ethos? And the answer is it will have no effect at all on the school's ethos. It's likely to make a larger proportion of the children in the school observant Jews. And that is the extent of the analysis that was conducted by Mr. Justice Mumby.
Perhaps the original idea of ethos did appear to be to suggest Orthodox Jewish practice. But perhaps the opposite is now being argued, that the ethos is one of a complete mix where one's striving to actually inculcate Orthodox Jewish. And perhaps they say that would be diluted if you had, or it seems to have moved to the other end of the spectrum.
Yes, and it's moved, we submit, in an impermissible way, because it wasn't the aim that was being put forward by the school before Mr. Justice Mumby, or indeed in the Court of Appeal. It's really emerging at the centre of the case at this stage before the Supreme Court. Can I now turn to the school's ethos as set out in the instrument of government?
Just before you leave, the point about the 5 extra people, you actually asked a question, I rather thought, which was trying to get some figures to enable you to do that kind of exercise, to which you didn't get a straight answer, I think.
Well, the only answer, that we got an answer of the number who had applied in particular years who were not halakhically Jewish. And my calculations, on average, if you take an intake of 300, it was about 5% of the applicants every year.
I see.
But that's in the light of its published policy.
Precisely.
Yes.
And one of the points that I'm going to I'll make it now, on the failure to balance the severity of the impact, is that there has been no attempt at all by the school to identify how many additional applicants there would be every year if it were to change its application policy. And, for example, if it were to have a policy that anybody who's regarded as Jewish by any of the 4 movements may attend the school, what effect would that have on the number of applications? That question's never been addressed by the school, and we submit, in the absence of any of those exercises, they're not in a position to balance the two sides of the equation. But that's just one of the factors they haven't considered. But I was coming to the ethos and the instrument of government, part 2 of the appendix, page 716. Paragraph 8 of the instrument of government, which sets out the school's ethos. Recognising its historic foundation, JFS will preserve and develop its religious character in accordance with the principles of Orthodox Judaism under the guidance of the Chief Rabbi of the United Hebrew Congregations of the Commonwealth. The school aims, this sentence has not been emphasised by Lord Panic, he relies mainly on the first. The school aims to serve its community by providing education of the highest quality within the context of Jewish belief and practice. It encourages the understanding of the meaning of the significance of faith and promotes Jewish values for the experience of all its pupils. Now, in my submission, the ethos of JFS as described there essentially raises a number of points. The first is certainly that the teaching in the school will be in accordance with the principles of Orthodox Judaism. And of course, we make the submission that it doesn't logically follow from that you should exclude from the school those who practice Masorti Judaism and are not recognised as halakhically Jewish, while letting in those who practice Masorti Judaism who are recognised as halakhically Jewish. But the second point is this, that the ethos refers to the school's historic foundation and that to the fact that the school aims to serve its community. And that is embedding the ethos of this school in its history and raising the question, what is the community that this school aims to serve? And my submission is that it is very clear that the community which JFS aims to serve is not and never has been the Orthodox religious community. On the contrary, this has always been the school for the whole of the Jewish community. I referred to the fact that the school was founded in 1732, long before there were any divisions between Orthodox, Reform or any other sect. And it was by the 19th century the largest school in Europe, a school of thousands of pupils in the East End of London. And it was the school through which the Jewish immigrants who arrived off the boats would send their children to have them anglicised, to have them taught English and proper table manners. And that is the origin of JFS, and you will see a very interesting extract from the history of JFS is in the bundles. But what is the school's community? We say that the best place to look for what is the school's community is in what the school itself says about what its community is. And if we stay in the appendix part 2, page 703, this is a JFS information sheet provided for candidates seeking employment there as teaching staff. JFS School is a highly successful Jewish co-educational voluntary aided comprehensive school with students ages ranging from 11 to 19 years. The school has a strong sense of tradition. Its origins date back to 1732 and the book on its fascinating history was published a few years ago. The modern JFS serves almost the whole breadth of the Anglo-Jewish community in Greater London. About 85% of its students are from Barnet, Harrow, Brent and Hertsmere. So the school itself is not claiming to be a school for the Orthodox community. It is saying almost the whole breadth of the Jewish community, the Anglo-Jewish community. Then they refer to their values. They say their approach is modern but not trendy, and their values are thoroughly traditional, reflecting the school's Jewish ethos. And then student population. Schools' admissions policy reflects positive selection to ensure a truly comprehensive ability intake. We aim to achieve a balanced intake across 4 ability bands. In addition to a thoroughly comprehensive spread of ability, our students come from the widest possible range of social, economic and religious backgrounds. Widest possible range. And that is then reinforced, we submit, by the statement that the school makes on its own website about its religious ethos. And we see this at page 751 in the same volume. The outlook and practice of the school is orthodox. One of our aims is to ensure that Jewish values permeate the school. Our students reflect the very wide range of the religious spectrum of British Jewry. Whilst 2/3 or more of our students have attended Jewish primary schools, a significant number of our Year 7 intake has not attended Jewish schools, and some enter the school with little or no Jewish education. Many come from families who are totally committed to Judaism in Israel. Others are unaware of Jewish belief and practice. We welcome this diversity and embrace the opportunity to have such a broad range of young people developing Jewish values together. And we submit that when one reads these statements together with the school's ethos and its instrument of government and asks what is the community that this school exists to serve, the answer is the breadth of Anglo-Jewry, the breadth of the community, providing teaching in accordance with orthodox principles for the breadth of the Anglo-Jewish community. And that is entirely consistent with the historic foundation of the school.
I mean, it may be a tiresome point, but actually that diversity will diminish if you're right.
My Lord, no, not on indirect discrimination, with respect, because we're now talking about the justification for indirect discrimination.
I know.
But my Lord, let me, this is important, because one of the points I'm making is that this school, if this is a question of indirect discrimination and not direct, this school could lawfully adopt a criterion of admitting anybody considered Jewish by any of the 4 Jewish religious movements, with no need for a requirement.
No, I appreciate that, but what here is stressed is there's going to be an intake of little or no Jewish education.
Yes.
Others unaware of Jewish belief and practice. Now, I mean, if you start using the touchstones of practicing the faith, I mean, you're going to have fewer of those.
Yes, but my Lord, we are at cross purposes, because on indirect discrimination, there's no legal obligation for the school to adopt a criterion of faith or practice. The question is simply whether, given the adverse impact of the criterion it has adopted on certain children, certain groups, it ought to have adopted a less discriminatory criterion. And my submission is that a plainly less discriminatory criterion would be to admit anybody recognised as Jewish by any one of the 4 Jewish denominations, Orthodox, Masorti, Reform or Liberal, without any faith or practice requirement. That criterion would have the effect that any child who had any form of Jewish religious or cultural affiliation would get into the school, would have the opportunity of getting into the school. It would broaden the diversity of the school in ethnic terms and in social terms. So this is central to the indirect discrimination analysis.
But the primary people discriminated against on the indirect discrimination argument are people who aren't Jewish by any test whatever.
That is correct.
And so that last proposition of yours wouldn't cover that. Ought they, on your argument, to open up the school to people who are interested in going there, and no doubt interested because of its moral values and educational standards, but who wouldn't qualify as Jews under any criterion?
There's no doubt that the criterion I've just suggested would also have an indirectly discriminatory effect on those who are not Jewish by any definition. However, one would then be in the position of weighing the indirectly discriminatory effect it had and the adverse effect on the excluded children against the school's aim. And my submission is that the balance in that situation would be fundamentally different, because the children you would be excluding under my proposed criterion are children who have no religious affiliation to Judaism at all, and no reason for going to a school like this other than that it's a good school, and there's no particular reason why they should get priority admission. But the the bite, the unfairness of the current criterion is the exclusion of devoutly Jewish children from devoutly Jewish families in favour of other children who have no religious affiliation with Judaism. That is the truly discriminatory effect on those children. That they attend synagogue side by side, they attend youth clubs side by side with other children, but they cannot accompany their friends to the school. They're excluded from the school. And that leading to the sense of alienation, unfairness, and a loss of dignity and autonomy, as expressed in the witness statement of the boy M. And we submit that the criterion that I'm proposing would have a far less severe impact than the one that's currently operated, which operates with great unfairness. If one accepts the proposition, which in my submission is inescapable, that this school is not simply seeking to serve the Orthodox religious community, but the whole breadth of Anglo-Jewry, including the Reform community, then one asks the question, how can it be right to say we'll take 90% of your children, but we won't take the other 10% because the Orthodox don't think they're Jewish? So you say you're serving the Anglo-Jewish community, but some of those are excluded. That's the point. Now, so that's what we submitted is the school's community, and we submit that the obligation on the school to consider the effect of its admissions policy on the faith communities that it serves is explicit in the admissions code. And we see this if we go to Authorities Bundle 12, tab 86. Tab 85. Page 55, paragraph 2.48. Admission authorities for faith schools should consider how their particular admission arrangements impact on the communities in which they're physically based and those faith communities which they serve. And we submit that this school has not taken account of the fact that its current admissions policy has an adverse effect on the faith communities that it serves, which include the Masorti, Reform and Liberal communities, because some of their children are excluded. We submit that the effects of the current policy are arbitrary and divisive on those faith communities. And your lordships and your ladyship have, of course, seen the letters that have been submitted by the leaders of those faith communities. Rabbi Wittenberg for the Masorti, the chief executive of the Reform movement, and Rabbi Rich for the Liberals. And it is very difficult for rabbis in that situation to come out and express their concerns, because the instinct of the Jewish community is always stick together, keep quiet, and don't say anything in public. But for those rabbis to make a public statement of the extent to which they abhor the requirement that has been imposed by JFS and its effect upon their communities, in my submission, is of the greatest significance. The next...
Could I just ask you
yes.
this? The role of the court in this context is simply to decide, is this right, whether or not the policy is justified.
Yes.
It isn't, the role of this court isn't then to speculate as to what might or might not be done in the future and
yes.
have a sort of several pages of possible analysis giving rise to
yes,
many more years of potential litigation.
Yes, Lord. Absolutely right. Absolutely right. And of course, my primary submission here is that the school cannot demonstrate, it has to prove that this provision is justified. It can't do it because it hasn't done any of the things it should have done to enable it to do that. It hasn't got any of the data. Now, the next point on that is the breach of Section 71. The school was under a specific statutory duty to consider the effect of its policy in race relations terms. And the court has seen from the witness statement of Arnold Wagner his blunt admission that there was no such consideration at all because they just didn't think this was a race issue. That has significant implications for the standard of scrutiny that should be applied to the justification. Now, time is short, and can I just give the court the reference? It's the Elias case, Volume 6 of the Authorities, tab 55, and it's paragraphs 128 to 133, 151 and 165, where it is made very clear by Lord Justice Mummery that, first of all, an ex post facto justification for indirect discrimination, whilst technically possible, is likely to be very difficult because there won't be the evidence for the discriminator to prove justification. And secondly, that a failure by the discriminator to have regard to their duty under Section 71 is a very serious matter, which again will make it much more difficult for the discriminator to demonstrate justification. And my submission is the reason why it's going to be so hard for the discriminator to justify is that the failure to comply with the Section 71 duty means that there has been no attempt to evaluate the severity of the adverse effect, and therefore the school is fatally disabled from conducting the balancing exercise that is necessary for justification. Also, another reference that I invite the court to look at, but I won't turn up, is the school's equal opportunities statement. That's part 2 of the appendix at 752, and it's clear from that that the school was under the impression simply that it was entitled to discriminate in its admissions policy, and that's another reason why it failed to conduct any balancing exercise. Some of the factors that we submit the school should have considered but did not. The first has already been canvassed. How many extra applications a year are we actually talking about? The second question is what other alternatives are available? Because there are a number of Orthodox Jewish secondary schools. We looked briefly at the admissions criteria of Hasmonean, which is a genuine Orthodox school serving an Orthodox faith community. So children who have an Orthodox faith practice have the option of that school. There are other Orthodox state secondary schools, including Yavna and King Solomon. But there are no secondary Jewish schools which will take the children excluded by this entry criterion. There is no alternative for these children where they can get a Jewish secondary education. And we submit that is a factor that JFS, given its historic foundation, given its role of serving the Jewish community, ought to have given serious consideration to. And that, of course, brings into play also, very acutely, the interference with the Article 2 of the First Protocol rights of these children and their parents. That these children were effectively denied any access to any form of secondary Jewish education. This factor and the impact of Section 71 are the reasons why I said to Lord Brown earlier that it is relevant that this is a state school. That the obligation on this school was greater because it is a state-funded school. It has particular statutory duties under the Human Rights Act and under Section 71 of the Race Relations Act to weigh the effects of its actions on the excluded children and the severity of the interference with their rights. And this it has not done. We also submit that what the school has done is inconsistent with the policy of the Secretary of State, as explained in the witness statement of Miss O'Sullivan. This is part 2 of the appendix, page 551. At paragraph 21 of her witness statement, page 557, she says, the presence of faith schools in the maintained sector adds to the diversity of provision and means that parents have greater choice when considering what sort of education they want for their children. Parents who wish their children to be educated in line with the ethos and values of their faith are able to do so without the need to pay fees outside the state sector. And then at paragraph 31, she refers specifically to Article 2 of the First Protocol of the Convention. And she makes it clear that the government considers that the system of state-funded faith schools is a method by which the United Kingdom fulfills its obligations under that article. Now, in my submission, the policy of this school is fundamentally inconsistent with that policy of the government because it deprives parents of the opportunity for the education of their children in accordance with their convictions and instead gives decisive importance to the convictions of the chief rabbi as to which children will be permitted to benefit from his education. And we submit that is inconsistent with the Convention and inconsistent with the government's policy. That cannot have overriding importance, as Lord Pannick submitted. Then at paragraph 34, Miss O'Sullivan explains why it's the Secretary of State's view that it's legitimate for faith schools to give priority to members of the faith without requiring religious practice. She says, at the top of page 561, that there are justifications for both approaches, i.e. a membership approach or a practice approach. School might decide children who have been born or raised in a faith should have the right to an education among children of the same faith, irrespective of whether the child or parents are active in religion. Secretary of State considers it legitimate for parents who are members of the faith but whose practice of the faith may be limited to wish to educate their children in line with the ethos and values of the faith. It may be felt by the family to be an important part of the cultural heritage of the children. On the other hand, another school might decide it will give priority to children who practice the faith actively. Other schools consider it's their role to educate the community at large. Secretary of State considers all of these approaches are valid in a system which values diversity. Now, absolutely right, those are all approaches that give priority to the parents' wishes to have the children educated in line with the ethos and values of the faith. But what she's not addressing here is a system which gives absolute priority to the chief rabbi's desire to have certain children prioritised because he thinks that those children are under an obligation to learn about the faith, and to ignore the needs of other children whose parents wish them to be educated in line with the ethos and values of the faith. She does not address the situation which arises in relation to the JFS of a school which excludes actively practising children in favour of those who are wholly inactive or indeed may practice a different faith entirely. And there's been no consideration, therefore, by the government of whether such an outcome is consistent either with its policy or with the Convention. So, my Lords, in summary, our submission is that Lord Pannick's case was, it must be proportionate to give priority to Jewish children, whether or not they're religiously observant, because the chief rabbi thinks that those children are under an obligation to learn about their faith and other children are not. And for the reasons that I've given, we submit that analysis, first of all, wasn't the analysis put forward by the school at first instance, and secondly, in any event, is plainly inadequate in terms of the Race Relations Act and in terms of the Human Rights Act. And my Lords, very briefly, other issues, alleged consequences for Jewish schools. I've shown to the court the admissions criteria that were already being used by the Hasmonean school before the decision of the Court of Appeal, and given you the references for other Jewish schools, Orthodox Jewish schools, that applied a practice test before the Court of Appeal's judgment. And in those circumstances, we submit there is no substance to the suggestion that a practice test is inappropriate in principle.
The practice test coupled with, in addition to.
Yes.
Yeah.
Oh, yes, that was the position of those schools.
Yeah.
But, of course, what's now being said is we can't work a practice test. And we say that that's obviously incorrect when one looks at the history of Jewish schools in this country. He also made submissions about the alleged consequences for other areas. Now, we've given the court our note, which deals in detail with the various hypothetical examples that were advanced. Can I just very briefly highlight in particular the example of the circumciser, the Moel, that Lord Pannick referred to?
Sorry, I didn't quite catch that. This is an example of...
The Moel, a ritual circumciser.
These examples, it seems to me, rather paled into significance compared to the primary effect on education in schools. One thing we weren't told, as I understand it, the current intake has been selected on the new basis. We haven't been... Is that not right?
No, my Lord. The new basis has been developed for next year.
Next year, I see.
This year there are... But your Lordship's right to say that, of course, 2 children have been admitted this year who are not regarded as halakhically Jewish. The heavens have not fallen. The school's ethos has not been harmed. Now, there is one other point I wanted to make, I'm sorry, that I ought to just make, which is that the new criteria that the school have adopted give equal weight to attendance at an Orthodox synagogue or a Reform, Masorti or Liberal synagogue. They do not seek in any way to prioritise attendance at an Orthodox synagogue. And in my submission, that is further weight to my point that the faith communities, I stress faith communities, that this school is serving are the whole of the Jewish community and not the Orthodox community. But just coming back to these alleged consequences, we address the problems of this approach at paragraph 8 of our note. At paragraph 9, we address in particular provisions in relation to facilities and services, and we deal with the MOL at paragraph 11. My Lords, then there were Lord Pannick's human rights arguments, which we submit again are entirely topsy-turvy. Yes, of course, there is an interference with the right of the chief rabbi to manifest the religious belief of the Orthodox. But Article 9.2 is a qualified right, and we submit that there is plainly justification for the interference, namely in the legislation, the 1976 Act, which is that priority is given to the right of the child to equality of treatment regardless of race discrimination, and that is powerfully underpinned by DH. Finally, in relation to the appeal on costs, which Your Lordship correctly marked has no impact upon us, since if we succeed, somebody will pay our costs, and we don't really mind whether it's the School of the United Synagogue. The only point that we've made is that we do not believe that any protective costs order was in fact made by Mr. Justice Mumby. Unless I can be of any further assistance.
Thank you, Ms. Mansfield.
My Lords, my Lady, first of all, the Commission wants to express its thanks to the Court for allowing it to intervene. I want to say that in the short submissions that I intend to make in the 25, possibly 30 minutes that I have, I shall follow very closely to the written case that's been put in, not obviously to read it all out, but just to add one or two short points that arise from the argument and which perhaps need to be developed a little bit further. But before I do that, can I make some very short prefatory remarks in relation to this? Obviously, we have no interests in the costs part of the appeal at all. But secondly, we've made no submissions at all in relation to indirect discrimination. We do not think we can add materially to the debate that has been already had. But in any event, the Commission actually sees this as a simple case of direct discrimination. And that is despite the length of the arguments that you've had so far. Essentially, the reason why it sees it as being a simple case of direct discrimination is very straightforward. The Commission does not like rules which divide a community of children on a basis which actually have absolutely nothing to do with the child itself, but have only something to do with where the child has come from. The Commission does not like that. It considers that to be absolutely squarely within the purview of the Race Relations Act, whether looked at as a piece of domestic legislation or as whether looked at in its wider context. The wider context that we need to say a little bit more about is the European context, upon which you've had, I think, so far, practically no submissions at all. But the essence of the point from the Commission is this, that under European law, powers exist to outlaw discrimination on grounds of race and religion and other grounds as well, contained within Article 13. And the relevant directives that are currently in play that cover this field here show quite clearly that at the legislative level within Europe, questions of the interface between religion and race have already been considered. And therefore, arguments of the kind that the current Education Acts ought to be read in such a way as to enable you to limit or read down or reconsider the definitions of race discrimination within the Race Relations Act should go nowhere at all. Additionally, we add that we will point out that the Race Relations Act itself expressly says that, in a sense, it trumps other provisions unless they are the necessary consequences of other legislative provisions, and I shall show you that in a moment. So that's in outline what we want to say. We want to add that we do understand, and we've made, I hope, this clear from our printed case, the tensions that have been expressed in this quote, both from the point of view within the Jewish community, but more widely the tensions between different kinds of equality rights. On the one hand, race equality rights, on the other, religious equality rights. Those tensions exist in a number of different ways in the field of equality law. This is only one example of those tensions. Other jurisdictions in other parts of the world have had to grapple with these tensions. You here have specific legislation that you have to apply. In other parts of the world, there are open text equality laws, such as in the Canadian Human Rights Act, where the Supreme Court has had to try and balance the tensions between competing equality rights. But we make it absolutely clear that we do not think that you are in that jurisprudential territory in this particular case, because the way we see it, the legislation has spoken, Parliament has spoken, and therefore that debate is not before you. It's a policy debate or legal policy debate that you don't need to get into. But we do see that in this wider context and make those points in our case. Now, can I start, therefore, by asking you perhaps to note really very quickly that those introductory remarks are made here in the first 6 pages of our submissions. They cover off, in particular, a reference to CERD, and I will need to say a little bit about the United Nations Convention. But I think the first point that may help this court today that I can add distinctively is that we also submit that Parliament has now expressed, in a sense, the purpose of the equality legislation that you have to construe. That's rather a rare thing, because usually you have to try and divine what the purpose of a piece of legislation is. But in the Equality Act itself, it has given you some clear clues as to what the purpose is. And those clues need to be brought to bear as and when you come to construe the specific provisions of the Equality, the Race Relations Act that are in play. Can I ask you then, please, to turn to the Equality Act itself, which is in volume 9, and you will find it at tab 71. And I want to take you to the first part of the Act, bearing in mind that this is the legislation which also introduced the protection against religious discrimination in Part 2, which you looked at in Mr. Panic's opening submissions, and I think was also referred to in Mr. Linden's submissions. But Part 1 is very helpful in our submission as to how you might want to go about looking at the issues in this case. The starting point is to note that the Commission for whom I speak are set up by Part 1. You can see that in Section 1. They have general duties set out in Section 3, to which I must return in a moment, and some specific functions in rather more detailed terms. If you note, please, the Commission shall exercise its functions under this part with a view to encouraging and supporting the development of a society in which, and I'll return to that in a moment, but the functions under the part are set out in Section 8, which is on page 4, and you will see that these are stated in this form. The Commission shall, by exercising the powers conferred by this part, then, I don't read it all out, but I do invite you to note the promotion of equality of opportunity, the promotion, awareness and understanding of the rights under the equality enactments, and the enforcement of the equality enactments. And if you'll turn for a second, keeping a finger in Section 8, unsurprisingly, the equality enactments are at page 25, section 33, defined to cover all aspects of this case. You'll see the Race Relations Act, Part 2 of the Equality Act, and the Equality, Religion and Belief Regulations at page 25, section 33. So we can see here the duty of the Commission is to enforce the equality enactments, and the way in which it is to do it is set out in section 3, and it is from that section that we begin to see, we submit, how these enactments are to be seen by the courts. Parliament has spoken by setting up the Commission with these responsibilities as to what lies behind the legislation in principle. And one sees there the set out at 3, the ability to achieve their potential is not limited by prejudice or discrimination, that there's respect for and protection of each individual's human rights, there's respect for the dignity and worth of each individual, and that each individual has an equal opportunity to participate in society, and there is mutual respect between groups based on understanding and valuing of diversity and on shared respect for equality and human rights. And we get a clue as to the meanings of equality and diversity in section 8, in subsection 2 on pages 4 and 5. This is the duties section. Diversity means the fact that individuals are different. Equality is equality between individuals. Now, all of that in our submission shows that Parliament expects this legislation to be interpreted from the point of view of the individual. Of course, it has to be construed in the context of the Race Relations Act as to whether the discriminator has discriminated. But the concept of the individual and the dignity of the individual is absolutely central to the approach to issues such as what ethnicity means, what race discrimination means in the widest sense, and so on. These are points we've made in our case, and we've developed further by reference to the European context. You will see that in our case, in paragraph 33, in which we say that the European context marches absolutely hand in hand with this. You can see the quotation from a passage which we could not possibly do better than to cite you. We certainly couldn't improve on it. The passage from Advocate General Juarez Maduro in the Coleman case, which I set out in full. Coleman is in the authorities bundle in the, I think, one of the last 3 volumes that have the reference for you. But one can see...
Has Strasbourg ever had to consider the tension that you referred to between race and religion?
My Lord, I didn't hear the first part of your question.
Has Strasbourg ever had to consider the tension between race and religion?
I don't know that Strasbourg has had to do it, my Lord. Somebody will correct me from my right. But certainly what I will show you is that the European Council, in legislating in this field, has had to think about the tension between religion and other equality rights. And I will want to show you that point in a moment. What one sees again are the values of autonomy and human dignity cited at the end of paragraph 8 from that citation, and in particular the passage in the middle of paragraph 9 and the last sentence of paragraph 9. And we say that that actually marches hand in hand with the way in which this court has been developing its understanding of the equality principles. And we've given at least one citation there from Gaidan Mendoza, but there are others that could have been advanced as well. Turning forward then to the next heading, the rights of religious educational establishments to make distinctions on religious grounds. The first point to say here is that, of course, we accept municipal laws enable educational establishments to make some distinctions, but there is no general right to do so that trumps, as it were, any other conflicting right. And we say that is particularly important and in any event that the European law has legislated within this field. We draw attention in 38 to the amendment to the Treaty of Rome in the Amsterdam Treaty, which introduced Article 13, and we also think that the court should be aware that the European member states at the same time made a declaration to the Amsterdam Treaty in paragraph 39 on the status of churches and confessional organisations, which would certainly include Jewish religious organisations. It is a respect principle. It doesn't go further than that, and as you will see in a moment, that principle is brought to bear when the European Council has in fact legislated. So far, all that Europe has done in the religion field is covered by the Employment and Equality Framework Directive, which, from its name, you will see, covers religious discrimination in the employment field. When I show you in a moment the Race Directive, that covers education and goes further than the Employment Equality Framework Directive. Could you turn to volume 11 for a moment, please? And we can look at the two directives. The Framework Directive is the second of the two and is at 76, but it may help you to note that its date, being the 27th of November 2000, is the same year as the Race Directive, which I shall need to say more about, being the 29th of June 2000. It's the previous tab. And I can say, because I was there, that these two directives in outline were proposed on exactly the same day. So they went through the European legislative process, not absolutely at the same time, in the sense that they were dealt with by European Parliament on different days, but they were actually discussed over the same period. Now, if we turn, please, to the Framework Directive, you can see that this covers discrimination on grounds of religion. One sees that in the purpose, which is Article 1. And you may want to note in passing the reference to Declaration 11 at Recital 24 and the reference to the Race Directive at Recital 10. And under Article 4 is a very important provision to demonstrate that Europe was looking at the interface between religious rights and other rights during this process. Article 2 defines direct and indirect discrimination. We don't need to look at it. It marches hand in hand with the municipal provisions in relation to this. But Article 4 provides an exception. It states, notwithstanding Articles 2, 1 and 2, member states may provide that a difference of treatment which is based on a characteristic related to any of the grounds referred to in Article 1 shall not constitute discrimination, where by reason of the nature of the particular occupational activities concerned, or of the context in which they are carried out, such a characteristic constitutes a genuine and determining occupational requirement, provided the objective is legitimate and the requirement is proportionate. But sub-article 2 is of particular interest. Member states may maintain national legislation in force at the date of adoption of this directive or provide for future legislation incorporating national practices existing at the date of the adoption of this directive, pursuant to which, in the case of occupational activities within churches and other public or private organisations, the ethos of which is based on religion or belief, a difference of treatment based on a person's religion or belief shall not constitute discrimination, where by reason of the nature of these activities or of the context in which they're carried out, a person's religion or belief constitutes a genuine, legitimate and justified occupational requirement, having regard to the organisation's ethos. This difference of treatment should be implemented taking account of member states' constitutional provisions and principles, as well as the general principles of community law, and should not justify discrimination on another ground. And then final paragraph, provided that its provisions are otherwise complied with, This directive shall not prejudice the right of churches and other public or private organisations, the ethos of which is based on religion or belief, acting in conformity with national constitutions, to require individuals working for them to act in good faith and with loyalty to the organisation's ethos. This was widely understood at the time to have emanated from a dispute from evangelical churches and church-based organisations saying that they would have difficulty with sexual orientation discrimination, as you can expect, and I don't need to go into it. But the key point about it was that Europe legislated to permit specific kinds of religious discrimination in the context, as it were, where otherwise there would be sexual orientation or other kinds of discrimination of that kind. And it's a delicate balance that you find set out in that provision. And it highlights the point I made to you here, that the making of policy in relation to this is a difficult legislative task, not one to be resolved simply by lawyers in a courtroom. You may want to also note, and I'm sure Lord Kerr will remember this, that Article 15 made specific exemption for religious difficulties in Northern Ireland, both in the police service and, more specifically, in the field of education in Articles 15.1 and 2. Now, my point is that while you see that in the context of the Employment Framework Directive, there is nothing equivalent to that in the field of the Race Directive, notwithstanding that it actually covers a wider scope. So if you turn back shortly to the Race Directive, I can't make a negative point any better than this, than simply saying, if you look at Article 4 of the Race Directive in the previous tab, it's a much shorter version of what we have just read. So we say here in the European context, the Race Directive was being discussed at the time as the Framework Directive. It covers education. You can see that from Article 3, which defines its scope, letter G in the about a third of the way down the right-hand column. And therefore, when you come to construe the Race Relations Act, you have to construe it conformably to the Race Directive. We've explained that in our case, and I don't need to add to it. It's cases like Litster and Marleasing and Pfeiffer which make that point for me. You have to construe it conformably with the Race Directive, and you must, we submit, notice that no specific exemption is made within the Race Directive for tensions with religious rights. And these, we submit, self-evidently must reflect policy decisions at the European level. My lords and my lady, I have set out in detail the analysis that we give to what we call the recognition sub-rule, and I want to just say a word about that, but if I can simply take the, I'm sorry, I'm going too fast, but it's one short point. If I can take the Race Directive point, which I've just made, back into the context of domestic legislation, and ask you to turn up the Race Relations Act, which you will find at volume 9 at tab 73. And if I can ask you to turn to section 41, and also if you can have to hand Hampson in the House of Lords, which was the one of the two loose judgments that we handed in yesterday. Section 41 was part of the original Race Relations Act, and This, in a sense, is the other part of the story that I've just been developing to you. In some respects, it can be said to have taken place before the Race Directive, because Section 41 was in the original Race Relations Act. And what it states here is that nothing in Parts 2 to 4 shall render unlawful any act of discrimination done, A, in pursuance of any enactment or order in council. I don't need to read on. And an early bit of litigation on the Race Relations Act was, what does that mean? Does that mean in circumstances where other legislation provides a discretion to a state body to do certain acts, that if it exercises that discretion in a way which conflicts with the Race Relations Act, it's immunised by Section 41? Or is it only in those circumstances where a state body is positively required to carry out an act of discrimination that it is immunised? Hampson in the House of Lords resolved that in favour of the argument that it was only where it was positively required, not where there was simply a discretion. Your Lordships will see that, I think, clearly from the headnote. Time does not permit me to take you through that. But what I would add is that Section 41 was made tighter, not looser, after the Race Directive, and you can see that in the square brackets, subsection 1A, which is added thereafter. So for all those reasons, we say the fact that there are discretions for religious schools to determine how that they will carry out their admissions criteria, and that they're immunised from claims of religious discrimination, goes nowhere in relation to the analysis as to whether or not there is a breach of the Race Relations Act at all. My Lord Hope mentioned the Percy case, and to some extent these same arguments actually arose in the course of the Percy case, which has been handed up. Time does not permit me, I think, to take you all the way through that, but can I commend to you Lord's Hope judgment at paragraphs 149, I beg your pardon, that's Lady Baroness Hale's judgment, Lord Hope's judgment at paragraphs 129 through to 130, really to the end, and Baroness Hale's judgment from paragraph 149, 152 as well, in that respect. Finally, I think, two very short points, because I'm running out of time, that I want just to make. If you could take the Race Relations Act up again, which is in volume 9. We do want to emphasise to you section 3.2, which we consider has not had quite sufficient discussion in the course of the debate. One of the arguments that seemed to be advanced by Mr. Lord Panic, was that this wasn't discrimination, this matrilineal descent rule, the recognition sub-rule, was not discrimination on grounds of ethnicity, because it was applied universally to one ethnic group, being the Jewish ethnic group. The critical point is that this is in part anticipated by the Race Relations Act, that there can be subdivisions of an ethnic group. And you see that in section 3, subsection 2. The point that I think was discussed by Miss Rose in relation to this is that, in essence, the ethnic group that the office of the chief rabbi seems to be specifically concerned with is, as it were, a subset of the wider Jewish group because of the specific religious condition that he applies. It subdivides the wider Jewish group. The Race Relations Act still applies to that subdivision. It's not enough to say that that there is a wider Jewish group if it actually has a disparate impact on one subset of that. We felt that was important to draw to your attention. And then finally, third, the race directive, in its recitals, explicitly refers to the United Nations Convention on the Elimination of Religion on Racial Discrimination. Time does not permit me to dig it out, but in our printed case, we've pointed out how discrimination on grounds of dissent is covered specifically within Article 1 of CERD. The Commission considers that to be particularly important in this case. It is not surprising to see it there. If one just takes the first, and often in the past, the more usual form of discrimination on racial grounds, colour discrimination, it is in fact a paradigm of dissent-based discrimination, colour. Colour comes from your parents. And what makes it objectionable is precisely the point about autonomy and dignity that we've spoken about earlier. It's something about which you can do nothing at all. And that's the same, we say, about dissent-based rules, such as this matrilineal line rule that is in play in this case. We don't have, I think, time here to discuss at any great length the background to the dissent rule. It is certainly not, as Mr. Panic has suggested in his printed case, concerned only with caste discrimination. And I make that point very clearly in the printed case, but if it's something that needs to be explored any further, then I will refer you to footnote 23 on page 31, where you will find a full exposition in Mr. Keen's, Dr. Keen's book, Dissent-Based, Caste-Based Discrimination, in his chapter on dissent-based discrimination. That's at bundle, if I can read my text right, 17 at page 131. And if it can be the last
17, tab what?
131 of bundle, Authorities Bundle 17. And I don't, I think, take any further time to discuss that now. It would take too long to do that in order to take you through it. But in our submission, it is perfectly clear that all forms of dissent-based discrimination are racial discrimination within CERD, and that the race directive was intended to give effect to that convention in the European context. My lords, I'm afraid I've gone at absolute breakneck speed, and I hope I've added something to the debate, but I will sit down at that point.
Thank you very much.
Well, as you know, I speak on behalf of the PHA in this appeal. We're very grateful to make these submissions as we did in High Court in writing and in writing. Can I make clear at the very outset, to deal with a concern expressed by Mr. Linden in his submissions, we are not asking the court to adjudicate on a complaint of religious discrimination which the claimant hasn't made, but we simply want to put the issues which are directly in play before the court into a slightly wider legal and factual context. And I'd like to do that, if I may, under 5 headings. The first, I want to take you briefly to the statutory admissions process which was actually in play here, which surprisingly you haven't yet seen. Secondly, I want to comment very briefly on direct race discrimination. Thirdly, on Section 50 of the Equality Act. Fourthly, on the question of justification. And fifthly, to touch briefly on the situation of other faiths. First of those headings, the statutory process in play here. Perhaps slightly surprisingly, the court hasn't actually yet been shown the statutory process that was in play here. If I can ask you to bring volume 10 of the bundles to hand, tab 74 of that, which you have seen, Mr. Panic showed you some of the provisions dealing with school admissions policies, but you actually, in my submission, ought to see section 86, which is on page 77. This is actually the process which was here being gone through, and I show it to you to emphasise the centrality within it of the parental position. The heading is parental preferences, and what is described as a process by which a local educational authority shall make arrangements for enabling the parent of a child in its area, first of all, to express a preference as to the school he wishes the child to be educated at, and to give reasons for his preference. Two limbs, what is the preference and why? 86 sub 2, subject to subsection 3, which is material, and section 87, which isn't material, the admissions authority, which we know to be here the governors, shall comply with any preference expressed in accordance with arrangements made under subsection 1. So there's a qualified duty to comply with the preference. Subsection 3, as I say, is in play over the page. The duty imposed by subsection 2 does not apply if compliance with the preference would prejudice the provision of efficient education or the efficient use of resources. And that reading within it goes to the school being full, in other words, up to numbers. But what we see in subsection 5 is this: no prejudice shall be taken to arise for the purpose of subsection 3a from the admission to a maintained school in a school year of a number of pupils in the relevant age group which does not exceed the number determined under, and then there's a statutory regime for determining numbers. And that is the framework whereby a maintained school cannot resist applications by parents where it is undersubscribed.
Using that word in the way I had always understood.
In the way, exactly, not in a qualified yes. JFS one, exactly. Positively got spaces. We, of course, are dealing with a situation where subsection 5 doesn't save the prejudice argument. We're therefore in a case where there's oversubscription, which falls within the notion of prejudice, the provision of efficient education for other children. So that's a subsection 3 disqualifier. So that's the basis on which a maintained school can resist a parental preference. But I also, just to remind my lords, that there is the requirement to enable parents to give reasons. And I say that's relevant to understanding the context of this regime. Where does that apply here? What we have in our submission is a ultimately surprising result, which is that in the admissions arrangements, and in particular in the oversubscription criteria, which the governors, not the chief rabbi, the governors have adopted, we end up with a situation which I can perhaps summarise this way, which is that faithful children are being displaced by faithless children. Mr. Panic put it very graphically. He said, and he's clearly right, that there may be children admitted under the chief rabbi's test who are not merely of no faith, but are actually, as he put it, actively hostile to the faith. And we say that jars. The idea that a faith school is admitting children who are hostile to the faith at the expense of the faithful, we say requires some explanation and analysis. My Lord, the second heading I mentioned is direct discrimination. We don't dip into this because it's not specifically our topic, but I make 2 points. The first is this: it was us who introduced in the High Court the example, the comparator of the apartheid white church. Not, I stress, to say that Judaism or indeed this school was operating in directly that way, but simply to illustrate the point which has been a big feature of Miss Rose's submissions, namely that one needs to distinguish between the grounds and the motive when it comes to direct discrimination. Very simply illustrated, as she rightly pointed out, by the apartheid church example, just because the church is doing it for, no doubt, bona fide religious reasons, does not mean that the court is not concerned to scrutinise the underlying, the substantive, the real issue. One looks, nonetheless, at what the actual ground is. Linked to that, my second point on direct discrimination, the question of membership criteria. We do not say that membership criteria as such are bad. The important point, however, is that they are not, in the same way as religious discrimination is not an answer, or religious test is not an answer, they are not an insulation to analysis of what is actually going on. What matters is the actual factual test that's being applied. So no answer that it's religion, no answer that it's a membership criteria. One has to look behind and see what's actually happening. Third heading, if I may, is section 50 and the Equality Act. My lords, my lady, have seen that in some detail. I just return to it fairly briefly to make a few points. What you have seen, perhaps it is worth turning it up, it's tab 71 in volume 9. What you have seen is that it defines discrimination, and then it applies that. Section 45 defines discrimination, Section 49 applies that to education establishments generally, including 49(1)(a) in relation to the admissions question. And Section 50 then says that those prohibitions do not apply in a fairly nuanced way to a school designated as this one is. Our concern is this, that exemption, that non-application, has been taken, we say, far too far, including by the Secretary of State. Mr. Linden said repeatedly that Section 50 authorises discrimination in faith schools. We say no such thing. Section 50 simply removes what would otherwise be prohibited. It does not positively authorise anything. It simply begs the question of what the wider law calls for.
Can you say that again? I can catch you coughing.
Section 50 doesn't authorise anything. It simply removes the prohibition on what would otherwise be unlawful. Yeah. It simply leaves one in the position of then saying, what is the position under the wider law? And indeed, I'll show my lords and my lady in a moment, that's what the Secretary of State's own code says. And indeed, in answers both to Lord Panic, from Lord Panic, and from Mr. Linden, in answers from the court, it was clear that they accepted that. Section 50 does not change the legal position of faith schools. It simply leaves them untouched by the new, as they then were, prohibitions in Section 49. I mentioned the code. Can I just take you to that to illustrate this very point? It's in in volume 12, tab 85. You've got this in several generations. You've been looking at it, not in the most recent version, but in the penultimate version, and I should carry on in the penultimate version because I don't think there's any material change. It's page 54 within tab 12.
Sorry, tab 12.
Volume 12, tab 85, sorry.
85.
Page 54.
Thank you.
It's paragraph 2.42. It makes the point that I've made directly in the Secretary of State's own words. Faith-based oversubscription criteria must be framed so as not to conflict with other legislation, such as equalities and race relations legislation, and with other mandatory provisions of the code. And we say that's absolutely right. Section 50 does not insulate against other legal requirements, including specifically mentioned race, but if I can add to that, for my purposes, the requirements of the Human Rights Act. Turning then to the question of justification, my lords, what's been dealt with in the centre of the case is the potential justification for indirect race discrimination. We simply want to refer, my lords, my lady, to the position of religious discrimination here under the Convention, under the Human Rights Act, which, as I've indicated, is still in play, notwithstanding the 2006 Equality Act provisions in the way I've described it. My lords, my lady, I don't go through the analysis. You have it in our printed case. I just refer you, if I may, to one brief authority, which is the Belgian linguistics case. You have that in volume 1, tab 8. The Strasbourg court here concerned with an attempt by one community in Belgium to argue for a number of things, including the requirement to provide schools in their language within Belgium. But if one turns to page 280, the European Court here looked at Article 2, Protocol 1, and also its relationship with Article 14. What we see, first of all, on page 280, the paragraph numbering is slightly tricky to follow in this judgment, but B is the heading, B2. We see them picking up Article 2 of the first protocol, and then we see at the foot of the page, remains, however, to determine the content of this right, identify that, and then over the page, importantly at the top of 281, Article 2, Protocol 1 does not require that contracting parties are required to establish any particular school. There's no positive obligation to establish a particular type of school. And we see, foot of the second chunk of text within that, it merely guarantees persons subject to the jurisdiction of the contracting parties the right in principle to avail themselves of the means of instruction existing at a given time. So you can't come along and demand faith schools. but on the face of it there is a right of access to them. Then we see on the facing page 282, moving from the first sentence to the second sentence of Article 2 of the first protocol, this is the one that deals with parental convictions. In the exercise of any functions which it assumes in relation to education and to teaching, the state shall respect the right of parents to ensure such education and teaching in conformity with their own religious and philosophical convictions. Important, I'll come back to it in a moment in more detail, important because it's directed to parents and to religious ... convictions. And the court then draws together Article 2 with Article 14 over the page on 283, paragraph 8, according to Article 14 of the Convention and so on. And then in a second chunk of text in paragraph 9, thus persons subject to the jurisdiction of a contracting state cannot draw from Article 2 of the Protocol the right to obtain from public authorities the creation of a particular kind of educational establishment. And then these are important words. Nevertheless, a state which had set up such an establishment could not, in laying down entrance requirements, take discriminatory measures within the meaning of Article 14. And we say that's very directly in play here, because it sets up the relationship between education and discrimination within the Convention. Within that context, we've seen, and Ms. Rose has taken you to it, the position of race discrimination in relation, in that case, to Roma children. So the court has directly considered the position of race discrimination in this context and said it simply cannot be justified. In the context of religious discrimination, again, I don't take you through the cases, they're mentioned in our printed case, but what we've seen is that religious discrimination has now become, under Article 14, one of the suspect classes that calls for particular scrutiny. We saw the court analyse that, the House of Lords analyse that in the Carson case, and picked up from the Strasbourg case of Hoffman, which again is mentioned in our printed case. Religious discrimination, now a suspect class, Hoffman says, again, can't be justified, but we accept, and it's an important chink we agree and accept, the position of Article 2, Protocol 1, which deals in its second sentence directly with parental philosophical convictions. And we recognise that that provides potentially a basis for justifying what would otherwise be impermissible religious discrimination. We are not here arguing, because we recognise that it would be a pointless exercise, that religious discrimination in faith schools is impermissible. What we say, however, is that the justification for it is a very narrow one. It comes from Article 2 of Protocol 1. If I can just develop that one brief way, it is to look at the printed cases of Mr. Linden and Lord Panic. If I just give you the paragraphs there, it's paragraph 69 in Lord Panic's printed case and paragraphs 58 to 61 in Mr. Linden's. That is where they set out the justification sections. But what you will see there, and I don't take you to it because time is limited, is that they talk in the most general terms about the justification for faith schools generally. The Secretary of State's case is directed at faith schools generally. They identify three potential justifications. One, they say, is Section 50. I've explained why in our submission that doesn't assist them. That the second that they refer to, and again they refer to it orally, is the position of the Code. But again, we say the Code doesn't actually provide a justification. It simply explains the Secretary of State's position. They both, in their written text, however, but not orally, also refer to the evidence of Sinead O'Sullivan and to Article 2, Protocol 1. But we say, notably, they were both very quiet in oral submissions on the position of Article 2, Protocol 1. Can I just show you how that arises in Miss O'Sullivan's evidence? It's Appendix Part 2, page 559. Ms. Rose has already taken you to this this afternoon, so I won't take it in length. But what you see, page 559, under the heading in the middle of the page, the aims and purposes of faith schools, the fundamental kicking off point for the Secretary of State is Article 2, Protocol 1. That's what paragraph 31 and following talks about. The second fundamental point comes on paragraph 34. And again, Ms. Rose has shown you this already. If you look at the middle of paragraph 34 on page 561, it's talking about the legitimate aim of parents who are members of a faith, but whose practice of the faith may be limited. So that is still nonetheless the faithful, albeit limited faithful, parent. But the essence of all of that argument, all directed generally to faith schools, is that the kicking off point, the potential legitimacy, is Article 2 of the first protocol. We say that matters because that is the chink, if you like, that allows for what would otherwise be impermissible religious discrimination to take place. That is the basis for faith schools. That matters, or the importance of that, one sees in the Campbell and Cousins case, Volume 2, just one paragraph I want to show you, Volume 2 of the authorities in tab 13.
How much longer are you going to take? Because you have 3 minutes.
Campbell and Cousins is tab 13. The paragraph within that is paragraph on page 304, paragraph 36. Second chunk of text in 36, directly linking, I don't take you through it, convictions in Article 2, Protocol 1 to beliefs and a linkage across with Article 9. So what we very simply say about all of that is that the chink that allows for what would otherwise be impermissible religious discrimination is the parental philosophical convictions, parental belief. And that is why we say the Court of Appeal was absolutely right to say, this is paragraph 33 of the Court of Appeal, that the criteria for JFS needed to depend, quotes, on faith. And that is why we say the answer that we have here, a faith school for the unfaithful, is wrong. And what is permissible, however, is faith schools for the faithful. And what we say is that our analysis leads to that conclusion and gives it legitimacy. Very finally, because I've gone a couple of minutes over time, we've included, and I hope it assists the court in our appendix, some information on other faith schools. We included it because complaint was made about the position or the impact, the knock-on impact of the Court of Appeal's decision on other faiths. If I can just make 2 points about it. First of all, a question that came from Lord Brown, I think yesterday, about the position of Sikh schools. You have these, if I may, just ask you to turn it up very briefly. Page 15 of our printed case gives you information about the admissions criteria at 2 faith Sikh schools. We have to apologise. There are actually 2 newer ones that we hadn't picked up in our search, so there are now 4. But the 2 newer ones operate very similar criteria. And to answer Lord Brown's question, the one that's referred to there, the Guru Nanak School, has been oversubscribed for some 10 years. So it's operating, we assume, those policies to deal with its oversubscription. And they are fundamentally faith-based criteria. And then just to correct an error in the section on the Catholic schools examples, on page 18, we've erroneously swapped subparagraph 7 and 8, the point simply being that La Santa Union is an example of a Catholic school which operates a baptism but also a practicing criteria. And we say those are examples of how there is only within Judaism and Catholicism are there anything like membership criteria in practice used, and even within those, practice criteria are also widely used. So we say the complaint about impacts on other faiths is wildly overstated. So, my lords, my lady, unless I can assist further, those are our submissions.
Thank you very much. Yes.
Thank you, Lords. My Lords, can I take the court back to what we apprehend is the core of the issue on direct discrimination? And can I clear out of the way what is not in dispute? It is simply not in dispute that if the ground of the decision is the ethnic origins of M, it cannot avail the school to assert a benign motive. The second thing that's not in dispute is that if the ground of the decision is a religious ground, that will not avail the school if the religious criterion, in fact, distinguishes between people by reference to their race or their ethnic origin. Example that's been given, the school that applies a religious test, but the religious test distinguishes between black children and white children. It's a racial test. The third thing that is not in dispute is that whether the decision is on the grounds of ethnic origins is going to depend on the content of the test, and it's also going to depend upon the attitude, the mind, the perception of the alleged discriminator, Nagarajan. All of that is accepted. Indeed, I hope it was accepted in my opening submissions on Tuesday. Now, where there appears to be some dispute, before I come to the core, there appears to be some dispute in relation to the issue that was raised this morning by my Lord Hope, because my Lord asked the question, is the context of significance? And we say most definitely yes. When the court is seeking to identify whether in truth the less favourable treatment is on grounds of ethnic origin, the context is of vital importance. And it's of vital importance not least because section 3, subsection 4, requires the court to ask itself what are the relevant circumstances, and the relevant circumstances will inevitably depend on the whole context. And that is why we say when the court asks itself in this case whether in truth the chief rabbi is acting on racial grounds, the court, we say, should bear in mind, it's not the answer to the case, but it's highly relevant to bear in mind the religious context of the function he's performing. He is a religious authority acting as such. And the disputes that he is determining arise in the context of and because of religious disagreements between different branches of Judaism about who is a Jew for religious purposes. It's of some interest also, incidentally, as Mr. Wolfson made clear, that all of these branches of Judaism, all of them, take the view that the criterion being applied is not a racial one. And the third contextual matter that we emphasise is that in this case, the chief rabbi's criteria and his decision-making is in the context of a statutory scheme which recognises the validity of faith schools. There is a religious context to the decision-making that is occurring. So in that context, the question is the chief rabbi here applying a criterion which distinguishes between people by reference to their ethnic origins? And I say that to constitute direct discrimination, whether it's on the ground of race or ethnic origins or sex or any other prohibited ground, it is necessary to show that the criterion draws a line between people by reference to the prohibited ground. Black people are excluded. Women will not be appointed, or they must satisfy different criteria to those applied to men. Of course, the distinction that is drawn may be implicit and not express. That's the point of the James and Eastleigh case. If you say that all those of pensionable age can enter the swimming pool for free, that draws a distinction. All men on one side, all women on the other side. But if the criterion under challenge does not make that distinction, it does not put people on one side or the other by reference to the statutory criterion, here ethnic origins, it is not direct discrimination. It may be indirect, but it's not direct discrimination. So the question is, what is the position in this case? And the criterion, you must be Jewish under Jewish religious orthodox law simply does not divide people by reference to their ethnic origins in any sense that is covered by the 1976 Act. We say what is so striking about the present case, and what in our submission distinguishes it from all other cases where direct discrimination has been found, is that it is neither necessary nor is it sufficient that you have, or that you are perceived to have, Jewish ethnic origins in the Mandler sense, because that's what we're talking about, in order to qualify. It is simply irrelevant. And one tests it in my submission in this way. Those who are excluded by the chief rabbi's criterion include large numbers of people who undoubtedly are of Jewish ethnic origins in the Mandler sense. Miss Rose's answer to that is it is the perception of the chief rabbi that matters. But the perception of the chief rabbi is that he does not dispute that there will be, nor could he sensibly dispute, that there will be thousands of people with the strongest possible claim to Jewish ethnic origins in the Mandler sociological sense who fail his test. They attend a synagogue. They observe the Sabbath. Their cultural and their social life is Jewish in every sense, every possible sense, but they still fail the test. Why do they fail the test? They fail it purely for a religious reason. They are excluded not because of their ethnic origins in any Mandler sense, in any sociological sense. They're excluded because of the religious test, the chief rabbi not being interested in whether they have Jewish ethnicity. And it is, I respectfully submit, a profound irony of the present case that the core of the religious dispute, which is at the heart of this case, the dispute between Masorti and the United Synagogue, the core of the religious dispute is that the religious criticism of the chief rabbi is that he ought to be more flexible and recognise as Jews people like M, who undoubtedly do profess Judaism, who do practice it, and who base their cultural and social lives around it. And yet, it is said, these people are not people with Jewish ethnic origins. Now, Mr. Allen has an answer to that point. Mr. Allen's answer to this point is that an ethnic group may have subgroups. See section 3, subsection 2. And the chief rabbi, says Mr. Allen, is subdividing the racial group. But the problem with that analysis is that it was analysed and rejected, in our submission, unanswerably so, by Mr. Justice Mumble. Can I take the court, please, to passages that you haven't looked at, where this precise point is analysed? It's in the appendix part 1, and it's at page 69. And at page 69, paragraph 165, Mr. Justice Mumby has set out previously the problems with the direct discrimination argument, and he addresses at paragraph 165 an answer. Miss Rose seeks to avoid the difficulty by reference to a second strand of argument. Not merely are Jews an ethnic group, but so too are various Jewish subgroups. So discrimination by reason of descent is in this context discrimination on grounds of ethnicity. But the difficulty here, as both Mr. Oldham and Mr. Jaffe pointed out, is that we are not concerned in this case with discrimination as between, for example, Sephardi Jews and Ashkenazi Jews. The discrimination is as between Orthodox and non-Orthodox Jews, and there is nothing to suggest that Orthodox and non-Orthodox Jews are members of different ethnic groups or ethnic subgroups in the Mandler sense. Indeed, in their character as Orthodox and non-Orthodox Jews, they are plainly not members of different ethnic groups or ethnic subgroups. As Mr. Oldham points out, there is no evidence at all to suggest that, for example, Orthodox Jews or Masorti Jews have distinct ethnic origins. As Mr. Oldham comments, given that the father of the child plays no part in the definition of a child as an Orthodox Jew, and given that a person may be an Orthodox Jew with generations of paternal ancestors of different nations, races, colours and religions, and given also the issue of conversion, it's difficult to see how Orthodox Jews, as opposed to Jews generally, can be a distinct ethnic group. Precisely so, the same analysis applies to Masorti Jews. Masorti Jews are defined only in terms of synagogue membership. Jews are all members of one ethnic group, and they may, though not by reason of practice or observance, also be members of different ethnic subgroups, for example, Sephardi or Ashkenazi. But that is all. That's the part of Europe that they came from. The Sephardi community coming from...
Isn't the problem with all this, though, that it suggests that ethnicity is biology? Suggests you've got to be able to look at the DNA and find something different. And as I understand it, I mean, in the Nazi era, some absurd distinctions were drawn by reference to the most remote connections which distinguish between people who would undoubtedly, in any objective sense, be regarded as the same ethnicity. But as I understand...
That's not the point. The point that's being made, if I may respectfully say so, by Mr. Justice Mumby, is that there is absolutely nothing to distinguish between different subgroups of Jews other than by reference to the Ashkenazi or Sephardi. There's nothing of any relevance to the present context where Mandler is focusing on sociological concepts, not, as your lordship rightly points out, on racial concepts. And once one focuses one's mind, as one must, on sociological concepts, it is true both that there are thousands of people who are ethnically Jewish, who have Jewish ethnic origins, who fall foul of the chief rabbi's test. That's the first thing that's true. And the second thing that is true is that the chief rabbi is simply not concerned with that. He has no interest whatsoever, and he's not drawing distinctions on that basis. And it cannot, in my respectful submission, it cannot be direct discrimination on the grounds of ethnic origin unless the criterion expressly or by necessary implication, as in James, draws that distinction. And it simply does not. The same is true on the other side of the equation, that there are many, many people with no sociological Jewish ethnic origins who the chief rabbi does accept as being Jewish for religious purposes. Again, he's simply not interested in the sociology. He has no interest in that whatsoever. And that is the core point in my submission on the issue of direct discrimination. It would, I say, be quite unprecedented to include within the concept of direct discrimination with no possibility of justification in any circumstances, a criterion which does not distinguish people by reference to the impugned ground, that is, their ethnic origins.
Could you deal with the point which Ms. Rose came back to time and again? Sorry. To the point Ms. Rose came back to time and again, which is the distinction between ground and motive.
Yes.
She says the ground is clear enough, but what you're really talking about is motive.
Well, I'm not interested. My submission is not a submission based on motive. I'm focusing on the ground in the sense that the court, my submission, needs to identify what is the touchstone, what is the factor, what is the criteria which puts people on one side or the other. That is the ground. The underlying reason for that is the motive, but the criterion that is applied to people, put them on one side or the other, is the ground. And here, it is not, in my submission, the ethnic origins of the individual, precisely because their ethnic origins, in the Mandler sense, in the sociological sense, do not determine whether they go on one side or the other. Now, I then have to deal with the argument...
Sorry, can I just come... I mean, could it be said that in fact, if Ms. Rose's criteria was adopted, namely that anybody, the school must take anybody who is converted by any of these strains of Judaism, then actually it becomes more by reference to ethnic origin.
I respectfully agree. Absolutely so. Miss Rose is seeking to bring into the test a criterion of greater ethnicity. I respectfully agree.
I must clarify that point. That I was saying that was permissible on the indirect discrimination argument. I don't suggest that would be permissible in relation to direct discrimination. On that, my position is that it would have to be a faith or practice test.
Thank you very much.
I then have to deal with the point that, in particular, I know my Lord Kerr was asking about during the course of the last 2 or 3 days. Does it make a difference, assuming that I can persuade your lordships and your ladyship so far, that there's no direct discrimination because the criterion does not place people on one side or the other, depending upon their ethnic origins. Does it make a difference, this is the question that has been put by my lord for the purposes of argument, does it make a difference that in fact the criterion focuses on descent, that it depends on who your mother is or was? Now my answer to that is that my friend Miss Rose concedes, and has to concede, that the mere fact that a criterion is based on descent does not of itself make the criterion one of ethnic origins. I gave the trite examples in opening of the grant of benefits to the sons of the SOGAT members or the hereditary peerage. So mere descent does not of itself mean that the criterion is a racial one. And I also remind your lordships that descent is only one of the factors which are relevant to an assessment of ethnic origins under the Mandler test. The court will remember Lord Fraser gives a long list of relevant factors, one of which, but only one of which, is descent. It's at page 562F. I certainly don't invite the court to go back to it again. Now, my submission is that in the context of this case, the fact that M's Jewish status depends on whether his mother had Jewish status cannot make the criterion into one of ethnic origins if it is not otherwise a criterion of ethnic origins. For this reason, to focus on the mother's position simply puts the same issue back a generation. And the same answer I say, should be given. The chief rabbi is simply not concerned in the Mandler sociological sense with whether the mother had or did not have the ethnicity of being a Jew. It is simply irrelevant. She may well, in M's case, have had the most distinguished of Jewish ethnic origins, but it would still be irrelevant. One could have, to take a hypothetical example, one could have someone who is now the distinguished rabbi of a Masorti synagogue. This is a purely hypothetical example. And his father might have been the rabbi of the Masorti synagogue, and his grandfather before him. They have the most obvious Jewish ethnic origins in any Mandler sense. But they still don't qualify because the rabbi's grandmother or great-grandmother converted in a Masorti ceremony.
Your arguments are all premised on the basis that the Mandler test is an alternative test to the narrow racial test. But when one reads Lord Fraser, he's saying that. He's saying it's wider, not limited to racial characteristics. It still retains a racial flavour, but it's used in an extended sense.
But there's no suggestion here. There's no suggestion here that this is a racial characteristic, that the chief rabbi is applying a racial test. The case against me has been put, and only put, on the basis that this is a test of ethnic origins. That's all.
Descent, wider than race, because it includes those who've been converted. We've seen that the chief rabbi will look right back to those who were servants in the temple.
But whether he's looking back, whether he's looking at M, or whether he's looking at M's mother or grandmother, he is still not interested in the extent to which, at any time, that person could be said or perceived to be a member of any Jewish entity in any sociological sense. That's the point, and it's the sociology that matters.
That sociology is all, and even if you can trace by genealogy and DNA straight up, that's wholly irrelevant. But in fact, that's one of the two ways that race or ethnic origin matters. Either it's a bloodline, or you've come in and been assimilated.
But then once one says it's a bloodline, then one has to deal with the other contexts where a bloodline is simply not adequate. If one's looking at ethnic origins, a bloodline proves too much. It proves that to use a criterion of descent is a racial characteristic. And it is not. It cannot be the case. It cannot be the law that under the Race Relations Act, the conferral of any benefit based on descent and therefore on a bloodline is racial. My submission, that is, would be nonsensical because of the examples that I give. And therefore one has to include, in order to avoid the absurdity of the hereditary peerage, of the SOGAT membership, one has to include the sociological sense.
Bloodline from a particular tribe or from a particular race, not bloodline from a footballer or a peer.
Well, but if one's looking at the peerage, one is going to trace back to a defined group of people who can be added to it.
Well, that's why you're doing it. If you happen to say, I am going to persecute everybody I can prove genetically is descended from a particular tribe or a particular race, why isn't that racial discrimination?
Because in this case, and this is how it has been argued, the Mandler criteria, which my friend Miss Rose has read and emphasised, form the basis of the ethnic group for which she is contending. She is not me, she is the one who is contending, and Mandler itself recognises that the Jewish community does form an ethnic group because of all the sociological considerations.
Lord Henry, you and Council keep using sociological. I suggest that anthropological would be at least as good.
Well, I'm happy to accept that correction. Indeed. King Ansell, the New Zealand case, proceeds on an anthropological approach in relation to whether Jews form an ethnic group, whether they have ethnic origins. Mandler and Lee proceeds on precisely the same basis. The Australian case in the federal court proceeds on precisely the same basis. And it does so because tracing back through ancestors is not going to illuminate the problems unless one has regard to all the anthropological factors, which include cultural factors, and religious factors and all other sorts of issues. And I repeat, in this case, the criterion that is being adopted is simply not drawing a division between people other than by reference to the religious criterion, which excludes large numbers of people who undoubtedly have all the anthropological factors which Mandler and Lee focuses upon.
I wonder if I might ask a question, Lord Penning. Do you say that M's being a Masorti Jew is comprehensive of his ethnic origin?
Comprehensive of his...
Well, let me explain. Is there a dimension to his ethnic origin which takes account not only of the fact that he's a Masorti Jew, but also that he is the son of a woman who is not converted to Orthodox Judaism?
No, I don't accept that the fact that she did not convert to Judaism through an Orthodox ceremony is part of his ethnic origin for Mandler anthropological purposes.
Well, let's leave that aside altogether. Does his mother's ethnic origin contribute to his ethnic origin?
It contributes in the sense that he may well say that part of my ethnic origin is that I'm Italian, if that's what your lordship is putting to me. But my answer to that is that that is not the reason why the chief rabbi excludes him. There are many people with Italian ethnic origins who are recognised by the chief rabbi. It's simply not the issue. So
what you say is that the attribute, if you can call it that, the attribute that she is not an Orthodox Jew doesn't inform the question of ethnic origin.
Yes, because I respectfully adopt the approach of Mr. Justice Mumby that one cannot distinguish in terms of ethnic origins and groups of Jews who satisfy that issue. One cannot distinguish between Jews who are Masorti Jews and Jews who are Jews according to the chief rabbi. That's the issue. So I invite the court to focus attention on whether or not the question of ethnic origins is in truth the dividing line between those who qualify and those who don't. And I emphasise that large numbers of people with highly developed Jewish ethnicity, Jewish ethnic origins, do qualify under the chief rabbi's test. The reason why M does not qualify is not because of his lack of Jewish ethnic origins. It is for other reasons that do not establish a difference that is based on ethnic origins. My Lord Walker asked a question yesterday, which was whether the problem in this case was foreseen by the Jewish community. Lords, the answer on my instructions is that it is striking indeed that until this case, no one, as far as we know, had suggested that the test of whether someone is Jewish, that is as recognised either by the United Synagogue or the Masorti or the Reform or the Liberal synagogues, is per se a racial criterion, ethnic origins criterion, under the 1976 Act, for the reasons, or for any reasons, but in particular for the reasons that have been deployed in this case. Now, if that had ever been suggested, of course, my Lord Walker is absolutely right. The Jewish community would have taken every opportunity to raise its concern about the implications, about the consequences of such an argument. But there's no evidence at all, and no knowledge, I'm instructed, of this ever having been taken prior to this case.
Is that proposition confined to this jurisdiction, or is that experienced throughout Europe? Or
well, we are not aware, I don't want to put it any higher than that, but we are not aware outside this jurisdiction of such arguments being advanced. And we have, as your lordships and your ladyship will appreciate, for the purposes of this case, given its importance, done some degree of work on all sides in seeking to identify relevant materials, judicial and others.
I see at the end of volume 13 we have an article on an Israeli controversy, and each adjournment I've gone away thinking I will read that article and haven't got round to it.
Well, can I invite you to read it? Tab 13.
I don't want to take up your time now, but
yes. My lords and my lady, my friend Miss Rose referred to the Clayton case. The court will recall the 1942 Trust case, volume 2, tab 18. Please don't turn it out. The court will recall that the criterion there was, quote, Jewish parentage. But there was no suggestion in the case that this was a religious test. And indeed, nor was it on all the material before this court. It definitely was not a religious test. And indeed, if one may most respectfully say so, both to their lordships and to counsel who appears, the court appears to have been blissfully ignorant of matters on which the members of this court are now world-class experts.
Sorry, what tab number was that?
Clayton, my lord, was volume 2, tab 18.
Yeah.
What the Jewish community did do, I say to my Lord Walker, was proceed on the basis of side that distinctions on the ground of religion are outside the scope of the 1976 Act. And side, I read the passage in opening, Mr. Justice Slynn, volume 7, tab 65, paragraph 21, Mr. Justice Slynn talks of membership. And there's been some debate here as to whether that's the appropriate criterion. But that's what he said in the Said case all those years ago. Now, I do respectfully invite the court in this context, that's the religious context and the historical context, to be especially cautious about expanding, as I say the court would be expanding with great respect, the concept of direct discrimination, which, to put it at its very lowest, because I appreciate there is some dispute about this, would be understood by the Jewish community, that's the whole of the Jewish community, as you've heard from Mr. Wolfson. The fear is it would do grave damage to Jewish education in this country, and it will cause real concerns about problems in many other areas. My friend's answer, Miss Rose's answer in her written paper, is to adopt what we say is the somewhat surprising approach of suggesting that the exceptions in the Race Relations Act should be given the most liberal interpretation in order to cover the problems that we have identified. We are doubtful, indeed, that even on the most liberal interpretation, that would be so. Miss Froese also told the court that in her submission, if her approach to direct discrimination were rejected, this would cause grave risks to the welfare of the Jewish community. All I can say, my lords, my ladies, is that as the court has heard from Mr. Wolfson, who speaks on behalf of all sections of the Jewish community, from liberal through to orthodox, they all take the view that the suggestion of direct race discrimination is simply wrong.
Can I just ask a question again about the background? Has there been any change in the strictness with which the test of whether someone is an Orthodox Jew has been applied in recent years? And secondly, has there been any change in the number of non-Orthodox Jews? I mean, I think we heard that in the 60s there was a change in the that led to the Jewish Free School becoming professedly Orthodox Jewish, and it was said at that time that was the dominant community. Yeah. Has that changed so that there are now more liberal reform progressive?
I'm not aware, my lord, and there's certainly no evidence to suggest that the approach taken by the chief rabbi to the question of who is a Jew has altered in any substantial degree in recent years. And indeed, given that the chief rabbi says I'm applying the rules as in Deuteronomy, it would perhaps be surprising if, other than at the margins, in hard cases, there had been any such variance. And your lordship will recall the evidence from, I think it was Diane Gelly, or it may have been Mr. Fry, that in this case, M's case, there was not even an application to the court of the Beth Din, because there's simply no dispute that M would not satisfy the test. But I'm not aware of any evidence.
I mean, the question perhaps arises more in the case of L.
Yes, well, in the case of L, there's been no change in the criterion that applied to L is that if you are going to convert, you must accept all the rules of Judaism as at the moment of conversion. And the difficulty, and one sympathises, of course, with the Lightning family, the difficulty is that entitles the chief rabbi and his court to say, by reference to later evidence, that the intention was not that at the time of the conversion. And that causes obvious distress. But the test has remained for many, many years.
What about the size of the relative communities, or the of the people who were here?
There is evidence as to the number of Orthodox Jews in this country, or rather members of the United Synagogue, which Mr. Jaffe, I'm sure, will find for me. There is evidence of that. And can I give your lordship that in a suitable moment?
In summary, there has been a very significant expansion in the non-Orthodox community since the Second World War. At the end of the Second World War, 97% of all Jewish marriages took place in Orthodox synagogues. The evidence in the bundle, I think, now suggests that something like a third of those Jews who are religiously affiliated are non-Orthodox, and about another third of all Jews don't have a religious affiliation. So there is much greater non-Orthodox. The Masorti movement only came into being in the 1970s, for example.
Lord, I'm sure that's right, and no doubt it is the consequence of the secular society in which we live and the greater opportunities for people to move out of their traditional environments. My friend then referred to the undersubscription criteria, and she pointed out that they were not a religious test. My Lord Phillips pointed out they're not in truth undersubscription criteria anyway. And my friend is absolutely right. There was no basis in Jewish religious law for them. The school's adjudicator said so. They have been struck out. They're not applied. And this case is simply not about the under-subscription criteria. My friend drew attention to the fact that the chief rabbi has recognised that Masorti Jews profess the Jewish religion. The court will recall the letter that my friend drew attention to? Well, of course they do. The Chief Rabbi was acknowledging this fact for the purposes of enabling Masorti marriages to be valid in civil law under the Marriages Act. And the Chief Rabbi was not addressing Jewish religious law at all in this respect. My friend, and I'm proceeding speedily, I hope that's acceptable, just to cover the ground. My friend relied on international human rights instruments. Miss Rose drew attention to the Convention on the Elimination of Race Discrimination, volume 13, tab 88, which the court will recall I dealt with in opening. It covers dissent, but I say what it had in mind primarily was caste systems. And in any event, the Danish case, the Danish MP, volume 1, tab 5, recognises that the convention was not intended to cover discrimination on religious grounds. Reliance was placed on the UN Convention on the Rights of the Child, which the court saw at volume 13, tab 87. But that does not forbid faith at schools, and it doesn't entitle a child to attend a particular school, especially a school which is designed for children of a particular faith, which does not recognise them as a member. In any event, there is a UNESCO convention dealing with education, volume 13, tab 89, which specifically recognises the permissibility of faith schools, articles 1 and 2b. Miss Rose and Mr. Wolfe relied on article 2 of protocol number 1. This is the right of parents to have their children educated in accordance with their religious or philosophical convictions. It's of note, I suggest, that Miss Rose expressly stated before Mr. Justice Mumby that this was no part of her case, paragraph 284. I can take pleading points just as well as Mr. Rose. On the substance of it, Article 2 of the first protocol does not confer any right of access to a school of the parent's choice. That's not what it confers. Nor could it sensibly do so. If a school is oversubscribed, there will always be parents and their children who will be disappointed. What Article 2 does, and there's a lot of authority to this effect, is to impose a negative duty on the state not to obstruct parents from establishing schools of their choice for their children. If the court is interested, it's the Belgian languages case, volume 1, tab 8, pages 280 to 281. The DH case, the Roma case in the European Court, my friend Miss Rose referred to, volume 2, tab 20, paragraph 176, Miss Rose says, the European Court have accepted you cannot justify direct discrimination in education. We agree. The question here is whether it is direct race discrimination. Finally, on direct discrimination, my friend Mr. Allen referred to dignity, the role of dignity as a concept. And I know my Lady Baroness Hale has written on this subject. We draw attention to the fact that this concept of dignity as an element of discrimination law has its origin in the jurisprudence of the Canadian Supreme Court. The Canadian Supreme Court has recently, and we will hand in a copy of the CAP judgment, recognised the lack of utility of the concept of dignity and the great care that needs to be exercised in using it. It's the CAP case, and it's paragraphs 19 to 23. Indirect discrimination. Miss Rose's case is that we left out of account a large number of highly significant factors. She says, look at Hampson, look at Hwang, look at Allenby. And it is of crucial significance to ask, is the aim sufficiently important? That's question 1 that she emphasises. Question 2, you must evaluate the adverse effect on the victim. And question 3, you must weigh the adverse effect against the need for the policy. Now, Mr. Justice Mumby referred to all the relevant cases, paragraphs 183 to 184, and he applied them at paragraphs 191 to 203. The relevant principles I accept, I do not dispute them, but everything is going to depend on their application in context. And in the context of a faith school, the aim is a fundamentally important one. Looking at the first question, is the aim sufficiently important? It is, after all, a faith school. Its essential purpose is to provide an orthodox Jewish education for children recognised by the chief rabbi, who is the authority, the religious authority. This is an aim that is of obvious importance. One doesn't need to assess it. It speaks for itself. The second question Miss Rose says we haven't asked ourselves is, what about the adverse effects on the children who are excluded? The adverse effects, again with respect, are obvious. There are going to be many, many children, and obviously so, like M, who do not get a place when the school is oversubscribed, who feel upset and aggrieved because they, ethnically speaking, are plainly Jewish, but they are not recognised by the Orthodox community to be Jewish. One doesn't need to assess this matter. It is blindingly obvious. The third question...
Well, we don't actually know that there are many, many of these, do we? I would suspect there are rather few of those who want to go to these schools. I would expect the vast majority do actually qualify. There are more who are qualified than there's room for.
Well,
we've got no evidence as to the size of this.
But we must assume, it being a first-class school, everyone agrees that this is an absolutely first-class school, that if the subscription criteria were different to what they are, children who are currently not given priority under the oversubscription criteria, of course, are going to want to go there. And many of them, why not, are going to be children like M. There's nothing exceptional about the circumstances of M, other than that he is a young man who takes his Masorti Judaism very seriously and wishes to go to a high-quality school in which he will learn more about Judaism in general. Why should the court, I respectfully ask, proceed other than on the basis that he's not going to be the only one?
We get a hint of the figures, don't we, in the answers to the statutory questions at page 1198.
We do. I'm grateful. And in any event, my answer to the point is that to the extent that the school admits one pupil who is not an Orthodox Jew as recognised by the chief rabbi, it is by definition going to be denying a place to one Orthodox Jew who is recognised by the chief rabbi. That's the inevitable consequence of an over-subscription policy. And given that this is an Orthodox Jewish school, of course, the school following the religious mandate of the chief rabbi is going to pursue the policy it does. My Lord Mance asked in argument, well, could one have a quota for hard cases? The general thrust of your Lordship's question, it wasn't specific words. Again, it is an oversubscribed school. I've made the point, one fewer places for the Orthodox Jewish children would inevitably result. But there's a further point. The code prohibits admissions criteria which focus on individual hard cases. One must have criteria which are objective. Miss Rose then took points on what the legitimate aim was said to be in our original evidence from Mr. Wagner, and she took points about the answers to the questionnaire. It is perhaps not entirely surprising in a highly complicated context of law that the answers given to a questionnaire perhaps do not give a full explanation of the case when analysed by counsel with the distinction and talent of Miss Rose in the Supreme Court. It would be astonishing if they did. But what matters is that the evidence adduced in answer to the claim most definitely did explain the legitimate aim. The evidence in particular of Diane Gelly, which supplements Mr. Wagner's evidence, and I do say, in relation to justification of an admissions policy of a faith school which recognises the religious authority of the chief rabbi, it is unsurprising indeed that the detail of the justification is given by the religious authority. That is Diane Gelly speaking on behalf of the chief rabbi. My friend also had a point that none of this was in argument before Mr. Justice Mumby, and in some way I have produced this argument in the Court of Appeal. I invite the court to look at paragraph 194, not now, but 194 of Mr. Justice Mumby's judgment. Then, my friend, and I'm coming to the end of these points, then, my friend, took the court to the instrument of government. Could I take the court back, please, to this fundamental document, Appendix Part 2, page 716. And my friend's point on page 716 was to emphasise in the fourth line of paragraph 8, Appendix Part 2, page 716, fourth line, the school aims to serve its community. And my friend says, well, the community is the broader Jewish community. But in my submission, one has to read that phrase. This is not a statute. One has to read it in the context of what precedes that statement. And what precedes it is that the governors, the majority of them, are appointed by the United Synagogue. The school exists to preserve and develop Orthodox Judaism, and it's under the guidance of the chief rabbi. It follows from that, in my submission, that it's perfectly obvious, particularly when one reads this with the oversubscription criteria, that the community that it is existing to serve is the Orthodox Jewish community, which, it is true, consists of large numbers of people who are not observant and who may not believe, but they are the community. And that is confirmed in my submission by all of the statutory material that the court saw, the role of the governors in promoting the Orthodox Judaism, the consultation regulations that the chief rabbi must be consulted on admissions procedure. My friend also drew attention at pages 703 and 751 to the wish of the school to cater for the widest possible range of religious backgrounds and to educate children whatever their level of religious practice or belief. But that, read in the context of the instrument of government and the oversubscription criteria, is referring to the broadest possible range of religious practice and belief of those children who are Jewish as defined by the religious authority of this school. My friend then drew attention to the code. she said, look at the code, volume 12, tab 85, paragraph 2.48. We must consider the impact on the faith community we serve. True, but we, JFS, see our instrument of government, do not serve any faith community other than the Jewish faith community as defined by the Chief Rabbi, which, it is true, includes large numbers of people who are not observant. Section 71 of the 1976 Act, my friend relied on the failure of the school to comply with Section 71. I rely on Mr. Justice Mumby's findings that there was a breach, a most regrettable breach, but Mr. Justice Mumby's finding, it's paragraph 214 of the judgment, is that this made no difference whatsoever to the substantive oversubscription policy. He said that the fullest and most conscientious compliance with Section 71 would not have led to any difference in the relevant part of the admissions policy. I rely on that.
Can you just tell me, I noticed, perhaps this has been covered and I missed it, but I noticed in the answers to the questions that there was a very small number in each year of non-halachic Jewish pupils. Where did they come from? Page 1198.
So your Lordship's looking, your Lordship has the advantage.
Page 1198 in part 3.
The answers to the question.
In the answers to the questions, yes.
Presumably this is
they were candidates. I'm grateful to my friend.
I see, this is candidates.
Yes.
They're what?
Yes, it's showing how many were rejected.
Yes.
Yeah.
And presumably, I mean, that's because everybody knows what the entry criteria are. I mean, if they were opened up, presumably there'd be a lot.
Well, they know two things. They know what the entry criteria are, and they know that it's a very popular school, and therefore will be oversubscribed each year. My friend then relied on other Jewish schools. She said, look at other Jewish schools, such as Hasmonean, Appendix Part 3, page 1373. They adopt, she rightly says, my friend, a test of you must be Jewish according to Orthodox Jewish law and you must practice Judaism. That is an additional requirement. It is entirely consistent with Diane Gelly's statement. And I should add, the schools which add this practice test are none of them, I am instructed, United Synagogue schools. They are more orthodox than the United Synagogue. The court will appreciate that there is, as has been indicated, a range of religious opinion, Judaism, to the right of the United Synagogue. The rabbis who are the rabbinical authorities are not the chief rabbi, and the United Synagogue is not the foundation body of any of those schools. Finally, and I apologise, I'm just at 4:30, but if I may, finally, I say that there's nothing in the reliance by my friend on Mandler on indirect discrimination and Orphanos and Elias. They all establish that what is required is to point to a legitimate aim, a proportionate legitimate aim, which is not based on ethnic origins. And if the courts were to accept our arguments on direct discrimination, then this is not a criterion based on ethnic origins. It is true, it may well have, indeed does have, a disparate impact in relation to persons who are not of Jewish ethnic origins, but that is always the case when one looks at justification, because unless you have a disparate impact on one ethnic group, you do not need to justify. And so there's nothing surprising about that. Our legitimate aim is not based on ethnicity, it's based on a religious obligation. Very finally, can I mention one other matter, subject of course to any questions? I'm asked to mention most respectfully, the timing question. I'm told that for entry in September 2011 in JFS and all other schools, admission arrangements must be determined by the 15th of April next year. I'm also told that there must be...
I think we might be able to manage that.
Mr. Allen, my lord, says it's a very simple case. But also there needs to be consultation before that, which would need to start early in January. But I understand, indeed I've instructed and I've advised, that we can go out to consultation on the basis of alternative options if the appeal succeeds and if the appeal fails. But the cut-off point is the 15th of April, and obviously the earlier we know before then, the better, in the interests of the schools and of all the pupils and potential pupils. Unless I can seek to help you, and I'm very grateful for the indulgence.
Lord Panic, I'm sorry to ask you to descend from the sublime to what may seem utterly trivial. There is an appeal on costs, and I don't know whether you have anything to say.
I'm sorry, I apologise. I have nothing to say.
Right, well, that's very convenient.
Not least because I would be embarrassed to say anything about it. I would have a conflict. I have no submissions, and my client has no submissions.
So it's accepted, is it, that if the appeal allows, your client will pay the costs?
We make no submissions.
Well, your appeal fails and his appeal succeeds.
Yes, yes. We are neutral on all questions. We won't be neutral if we win the case, then we will have a submission to make anticipate.
We are very grateful to the Council for their submissions and will reserve them.
Thank you very much.